Good afternoon, everyone. I'm sure everybody is very well rested after the lunch. So we'll try and make it a little engaging for you. Thank you, Legal, for having us here. We are going to be talking about white collar. I think the most spoken about topic in the era of today. Crime has been there since centuries, but the definition of crime has undergone a change over a period of time. When we spoke about the Harshad Mehta scam, it was a shocker because that nobody could expect a stock market scam, and then that led to SEBI. But now with the derivatives fraud that we are seeing in the IndusInd Bank portfolio of asset liability desk and the trading desk, we've realized that the definition of crime keeps evolving. They say that, criminals are smarter than, than the police always, so they find new ways. And obviously, the previous session spoke a lot about on technology and AI. So with the advent of technology, there has been an increasing change in the way the crimes have been committed in a country like India, which is vastly populated and goes up to different remotest villages where these scams happen. It took us 110 plus years to understand that we need a change in our criminal law system. In 2023, our entire criminal law system changed when we brought in the Bharatiya Nyaya Sanhita and the Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Sakshya Adhiniyam. We've picked up our laws from the British, but we've kept them very, very regressive and very, very old pattern. And we've realized that with time, crimes have become very localized. What may be a crime in Delhi may not be locally occurring crime in UP, and with borders changing, the nature of crime also changes. In this background, we've had increasing dependence on forensic investigators also, not just for giving some credence to the source of investigation, but also to see how these technical aspects of a crime can be covered by people who are experts in the field. We are not living in an era today where lawyers are sitting and saying, oh, do this to find out what happened in a crime. We are in an era where we have forensic investigators, and they very sophisticatedly, in an internal investigation, find out what has happened, so that there is some paperwork that you can defend. Economic offenses, financial crime, all these are like unlike traditional crimes where you have a paper trail. So if you have the right machinery in place to investigate them, I think it's very easy to prove a crime like this, which is why we've had situations where even the government has now started relying on forensic investigators. In this background, I would like to put up a question to Shiv. How do you think white collar crime has gone beyond traditional crime, and what do you think has been the approach? How is the Supreme Court seeing white collar crime in line with the Sansera judgment?
Thank you. So just to point out something, any criminal who gets caught is an accused. The criminal who doesn't get caught stays as a criminal. Now, if you see Sandesra's judgment, what we are seeing now is a recovery first process rather than punish first. In this case, you had 5,100 crores being recovered from banks, obviously voluntarily through a OTS settlement. Just a week later, same bench of the Supreme Court refused a OTS settlement to quash the criminal proceedings, where the bench held that since this emanates from PC Act offences, therefore we will not intervene. But that was the exact same case with the Sandesra judgment as well. Sutherland defines an economic offence or a white-collar offence as something that does not cause violent harm. What we are seeing ourselves evolve into a society today is multifaceted investigation by multifaceted organizations. When we had Harshad Mehta scam, it was only the CBI that was involved. Today, take for example Sandesra. You have Fugitive Economic Offenders Act, you have the CBI investigating the PC Act, you have the Enforcement Directorate investigating the PMLA. 3 separate agencies. To add to that, you have the SFIO investigating the Companies Act. 4 agencies. So if you say that, Shiv, it's a positive view to curtail 5 investigations, curb 6 complaint cases and 2 FIRs, you can say yes, very practical view. So therefore, recovery first and punish later. But if this view is not consistent, What we will not derive is some level of consistency. And consistency is the bedrock of any jurisprudence. So today, if Sandesra can get away with it, why can't another organization? Which is why I'd like to pose it back to the other panelists. Is there a possibility that now the Supreme Court can formulate guidelines beyond the state of Punjab judgment? That can it go and say that yes, in these cases where if you come within a certain timeline, you can now go ahead for a quashing?
As much as the Supreme Court may want to recover the money, first you have your ED which wants something else. So they will come in even where they don't have a power. But it's appalling for me to know that Supreme Court had to tell them in the Chhattisgarh excise scam that, you know, there is no predicate offense and your proceedings are totally illegal. And it went on to a stage where they eventually, after getting a quashing from the Supreme Court, registered an FIR, and then, you know, the state registered an FIR, constituted a sit, and then ED came in again. So it's pretty much like a premeditated thing. As a law firm lawyer, I feel that lawyers are very, very reluctant to touch the technical aspects. So Gary, what is your view on the role of a forensic expert in investigation of a financial fraud? Do you think that it's undergone a change in the last few years, or you think it's the same and you've always been there doing the same thing?
Thank you. Very relevant question. Sorry for the sore throat, but I'll try to be at least speak, and thankfully this is not a singing competition, so I can survive. So we talked about technology, and if you look at technology, not only the courts are adopting technology, but your complete life has adopted technology. Your banks are your own phone. Your OTT is on your phone, your Zomatos, your everything is on phone, everything has become technology. And the frauds are also linked to technology. So every next day, deciphering means of fraud, trailing the beneficiary, even after finding evidence, interpretation of evidence is going to become more complex. So that is the reality we're facing. So it has to be a time when more and more cooperative approach will start playing a role, rather than the traditional style of, okay, here is a crime, here's evidence, it's over. So rather, it evolves every day up to an extent that even if you have something ready as an evidence, different lawyers can interpret it differently. So not only lawyers presenting it, your expert witness along with you to ensure it reaches the right result. I'll just give one case that we were working upon, B.R. Shetty in Dubai, 88,000 crore company being finally sold at 74 crores. And believe me, it was almost a situation that B.R. Shetty would have gone harmless. He had given affidavits, I've got no assets, I got nothing, it's all just a business failure. When we came into play, we found his assets more than 400 crores. We found many other cash tracks which were plus 200 crores, and things started turning. So it was, if left to, without the forensic support, means this could have been just shown as a business failure. So complexity is increasing. The cooperation has to increase to really get criminals get the right result which they deserve.
Thank you for your views. I totally agree with you. Even in the Qatar food scam, if it wasn't a financial audit done by technical people, they actually hid the fact that they had no rice and no grain lying with them. So I do understand that getting deeper into this matters. Sidharth, what is the right stage for lawyers and investigators to collaborate on white-collar cases? When do you think is the right time for you to get in touch with Gary if there's some investigation that you're foreseeing?
Yeah, thank you for your question. Good evening. In fact, just before starting this discussion, I was discussing with Shiv as well. But I think the right answer to this is the moment something triggers in the company, I think the lawyer should set in, because as Gary was also saying, it's become so complex. Though he was talking from the prosecution side as to unearth what has gone wrong. But there can be situations for lawyers or companies when you have to defend it properly as well. Sometimes something very small can spark into something very, very big for a company. So whether the company has to go for internal investigation, what the company has to do, whether an offense is made out, what has been done, what has triggered, what has set in, if there is any report of the forensic, how it is to be looked into, how the investigating agencies would look into, to what extent the agencies can come in, how they can step in, what are the materials they can look into, what can be destructive for the company, what can ultimately bring the company to a very difficult situation. All that has to be first gauged, I believe, at the level of a lawyer, because ultimately a lawyer is the one who's ultimately defending the company, the last action in the court. And of course, all what agencies do are ultimately replied by the lawyers in the court in order to see it as to how it comes into the practical form, because whatever Gary may do or the forensics independently may do will be all in-house at the end of the day. But how it is seen in the court and what is the law on that, right? Like supposition, whether can you take something self-incriminating of a person, whether you can take the voice sample or not, voice samples can be taken, whether there is any evidence which is in such form. So my answer to you is that, of course, the moment something sets in, it is the lawyer who has to decide where the company has to go to.
Thank you, Sidharth. Since you said lawyers have to decide everything, Vivek, what's your view about summons being issued to Mr. Datar and senior counsel Mr. Pratap Venugopal, because both of them were playing very different roles when they were summoned. And we will obviously come to the suo motu judgment later. Supreme Court did stand up in a couple of cases, but then the suo motu judgment almost said it's like reinventing the wheel for company lawyers who are GCs. So what do you think is the learning from Pratap Venugopal's judgment? Because he was issued summons by ED for being an independent director in the Care Health investigation. And to the best of my knowledge, independent directors are always exempted. Even in a small 138 case, I've seen judges asking us, no, tell me the role of the independent director. Why are you coming after him? So summoning a senior advocate and an independent director and then a senior counsel for giving advice, overlooking the mandate of Article 20, Subclause 3 of the Constitution. What do you think? Where are we? Should lawyers really get into all this?
Well, this was clearly a face-off between ED and lawyers per se, and then Supreme Court rightly intervened there. The case, in fact, originated with regard to an opinion which was given by Mr. Datar, and then at that time, Mr. Pratap Venugopal was advocate on record in Supreme Court, and then he was briefing Mr. Datar. So it was employee stock option on the issue that was there with regard to the company, in which Mr. Pratap Venugopal was also an independent director. So initially when, prior to Mr. Pratap Venugopal, notice was issued under Section 50 of PMLA to Mr. Datar. Supreme Court AOR Association filed a resolution before the court that first of all they sat together and then raised a voice against it, and then they gave a representation to the Supreme Court Chief Justice. But nothing had happened at that stage, because by then ED had already withdrawn that notice. Subsequent, after few days, Mr. Pratap Venugopal got the notice. And on that, again, the Supreme Court AOR Association raised voice, passed a resolution, and then represented before the court. But at the same time, Supreme Court took the suo motu cognizance. In the meantime, ED suo motu again withdrew the notice, but it also came with the explanation that it is in the capacity, his capacity of being an independent director of the company. So being independent director, you have nothing to do with the company. You are only overseeing, means a particular specific area, domain. You have no control over the company. So anyone who is having the control over the company can be summoned under Section 50. Otherwise, unless there is direct evidence involving a person, he may be third party, may be lawyer, then Section 132 of BSA comes into play. So if suppose I have no role to play in a possible crime which has been committed, I am only an advisor, being a lawyer, then there is nothing that can be done against me. But if I am participant in the crime, then in that case I can be summoned. So the elements of summoning under section 132 were completely missing, and Supreme Court took cognizance of this. So this had been a very serious matter, and it would have in coming time some implications also, because ED would also try to find some passage through the judgments that are being passed. So let us see how the situations evolve in coming time.
Absolutely. So, how I see it, general counsels play an internal advisory role, and with the suo moto judgment, how do you think it's going to play out for GC Shiv? Because if I am a general counsel of a company, and there's any conversation happening, there's no attorney-client privilege that I'm attracting, I would not want to be in that room. We all know how ED acts, and why would I want to go to the ED office for questioning? So is it a step forward or is it a step back? Is it holding accountability for GCs? How is that different from a GC advising a company to an independent lawyer advising a company?
Very pertinent question.
And we are just 4 minutes into it, so let's keep it very short.
Very pertinent question. I think Supreme Court has missed an issue here. The statutory framework of 132 versus 134 is very different. 132 confines itself to advocates, whereas 134 expands itself to legal professionals. Now a GC is no less than an advocate, because the only difference is he has one client versus us as independent counsels have multiple clients. He is upheld to the same level of ethics. It's just that he has given up his license to work for a company. The reasoning Supreme Court has given is that he is not amenable to the Bar Association, but is amenable to his master. Now this concept is not there throughout the world. When we're advising clients across different jurisdictions, you will find that in the UK, a general counsel is protected, and the same in the USA. But now if a general counsel travels to India on work and advising a multinational corporation, his privilege suddenly vanishes the moment he enters into Indian shores. This is a very key issue, and to get over this, companies have to employ what we call a GPP, a Global Privilege Protocol, to decide under which protocol you can act and which protocol you can advise. Your advice has to be strictly legal. Where the GPP is not favorable, you must engage in external counsel. Even to conduct a forensic audit, like Mr. Batra said earlier. That forensic audit, if you are getting conducted by your GC, and it has to be, and you are summoned, you are obligated to inform them. Once that obligation is waived off, then I'm sorry, but you are stuck. So for that instance, get in an external counsel. So there are multiple steps you can take. Segregate your communication from GCs and segregate your communication from external counsels to see which communication will be privileged and which not. See which border jurisdiction protects you. If the jurisdiction of UK protects you, have your conversations outside India and make sure that there's a clear line of communication between you and your client, and you don't get these issues mixed up. And also don't circulate legal opinion within your company. And very shortly there will be an application that is going to be moved in the Supreme Court on this issue to expand the scope and to see how the Supreme Court will come back on the issue of 134.
Thank you, Shiv. Gary, do you think a strong coordination between the legal team and a forensics team is essential to a robust investigation? Have you had instances where there has been a disconnect between the legal team and the forensics team on anything concerning the investigation, whether it's the manner of collection of evidence or whether it's the way you are interpreting an evidence, and how do you navigate situations like these?
No, sure, thanks. Very relevant. But I want to take a step back even before I say the cooperation during an investigation. One thing, some of you must be doing it, but my complaint to legal community, all GCs and all external counsels, why you're not part of preventive actions? Why you're treated like a doctor, jab tak bimar nahi padenge, inke paas nahi jate? Why you're not creating that image that I can give you preventive actions as well? So that's first. And if they are not done, that's where the challenge of complexity increases. Coming to the next stage, which you said, if there is something wrong and investigation takes place, one of the biggest disconnect we find is because yes, we may have some internal legal counsel tell us how the evidence is presented, but one of the biggest disconnect again remains, no, I only need 3 answers. Who's the beneficiary? how it has happened. I said it is not a single step anymore. There are mule accounts, there are long chains, and a lot of time the beneficiary might be a Benami entity. So in that case, we had like you said, we had a very unique situation. When from a large mining company, thousands of crores were swindled, and there was no trace of where exactly the promoter has taken it. We looked at another way, and we found a lot of relatives were holding these assets, which were land banks, which were future going to be raised as townships and things like those. So when we said, here are the two situations, they said, no, it doesn't help me. I said, why don't you put a case on all those guys who holding 1,000 crore of land and never filed income tax? Take that action. They will stand up and say, no, this is not mine. So a lot of time, the innovation on both sides can work. So that's how possibly we need to look at.
I think, Gary, because prevention doesn't happen because it's managed internally, and with what Shiv has said, I think GCs are going to step away from it. It's going to help the external lawyers. But Sidharth, your closing remarks on, do we require any, because Gary raised a very pertinent issue, do we require any ethical or professional boundaries that need to be drawn between counsels and investigators?
You see, it's very interesting. It's a big list once you start reading it. In fact, I read it for the first time, Vivek, when I gave the AO exam. It's actually true stringent. The Britishers have left. Of course, we follow the common law system, but if you read the Advocates Act and the Bar Council rules, in fact, there is a limit on how big can your board be as well. The board that you put outside your office has to be this size, otherwise it will be a misconduct. You can't write yourself as an advocate, Supreme Court of India. That's a misconduct. You can't write like that. So it's very stringent, if you ask me. And of course, when you're entering into a company or a client which is going investigation or would be investigated later on, something goes left and right, where, in fact, again, I was discussing with Shiv, you tell somebody to delete your data, right? And that comes on the record. There, of course, the trouble brews up, and that can be a difficult situation. So all in all, of course, I believe for me and for all the youngsters, we must read what is there in the Act. The Act and the Bar Council rules, in fact, give us a very little window on what our advice has to be and how it has to be.
Thank you, Sidharth. Since the time is up, I'm going to put my last question to Vivek for his closing remarks. Vivek, I don't think involving lawyers, the intention is to nail the lawyers. It's an element of frustration on how lawyers advise clients to deal with investigations. Do you think summoning lawyers is a veiled threat to lawyers to not act in a manner and directly impinge on a party's right against self-incrimination? Because if I am compelled to appear and I have to make a statement on what I discussed with my client, obviously the Supreme Court said you can't do that. Someday if something like this, or if it doesn't happen, what is the intent of the investigating agencies? Is it to impinge on a party's right to right against self-incrimination, or is it threatening the lawyers to step away? What do you think is the larger objective behind it?
The underlying savior for a client is the lawyer. So when the lawyer is trying to save, and if you attack that lawyer, so then you have the entire gamut open before you. So that might have been the intent, but be that as it may, what is the frustration within the investigating authority that I see? Today, the investigations which are roaming around, we are still doing it, means we are lack of forensic professionals. All the investigations which are required to be looked into in today's scenario, we need at least 10x experts in the investigating authorities. Those people are just not there. So there is a deep frustration within the investigating authorities that they are not able to, find out proper ways and methods as to how to do, and then there are time lagging. Then in the court, they have enough power to arrest anyone and not to get released, and the courts are also not releasing them. So that power combining with that frustration, bringing some kind of vacuum in between where the lawyers come in. And that's, maybe the future targets. So what is required, of course, you need to have, whenever you are with the client calls and with the informing the client about any decision making pertaining to any opinion, pertaining to any question. So you must need to codify so that you could, provide your innocence. Because that is that one thing which has opened today could be in multiple in coming time. So be careful. And of course, in coming time, because forensics would be a requirement, so all of you would need to upgrade your talent with regard to how to read the forensic information, reports and all.
Thank you, Vivek. Thank you, everyone. That was an interesting session. The panel wanted me to ask questions, but I think that we just heard a bell, so we'll wind up now.
Yeah, let's just we stand here. I'm very
Thank
sorry
you.
for that.
Thank you so much.
But thank you so much, and thank you, ma'am, for moderating it as well. Please.